DPP say? What does the DPP in the area where this allegation is made say in this regard? Second to that, Chair, is just to find out if whether are there oversight mechanism between the NDPP and divisions. Because my view is that if there exists oversight mechanism, red flags should have went up long time ago as far as this case is concerned. When an application by the defense for a mistrial came up, questions were supposed to have been asked. Charges being reduced from 63 to 34 or around that, flags should have been raised. Allegations of misconduct by some of the prosecutors, and obviously the length that this case has taken, the multiple postponements would have triggered a response or a reaction from the highest office to ask, why is this case dragging for so long? And when it's actually a case about a serious matter like sexual offenses. Now, Chair, the other point that I hope that the report will cover is when the investigation that is being currently undertaken, how will those that are in the employ of the NPA be protected from victimization? And I'm asking this, Chair, because the judge speaks about the issue of a senior prosecutor asking witnesses to perjure themselves, a junior prosecutor raising this concern and observation with those that are senior to her. And that is Advocate Serfontein. And nothing was done. Now the question becomes, should there be a situation where Ms. Serfontein is required to come and assist the investigation? What measures are in place to ensure that she's not victimized and she is shielded from any form of victimization? Because the mere fact that she stood up and spoke against her seniors will put her in a very difficult situation going forward, even though her plight at that time was ignored and the prosecutors concerned were allowed to proceed. Now, Chair, linked to the initial point of the accountability model, I'm also interested to find out if whether is there a clearly defined complaints process when allegations of misconduct are raised against prosecutors. I believe that when the allegation by Mr. Fontaine, and which were proven, were raised, and those allegations were put through a particular defined process, the person who was accused of making that particular intention to have witnesses perjure themselves would have not proceeded with the case. That's at least what I believe. Chair, maybe I'm going too far, but a direct question. Is there an investigation to see if whether the assassination of Ms. Pamela Mabini is in any way linked to this case? We know that she was very vocal, and in the public space, there would have been allegations or sentiments growing that her assassination could have been a way of intimidation, either to witnesses or any other concerned party that might have wanted to play a role in such a case or in others going forward. Because we all know that when she was assassinated, in the very same month, there would have been another assassination of an activist against GBV and sexual offenses. The effectiveness of the Office for Witness Protection linked to the case that I would have alluded to now. How effective is this office? Is it being properly promoted enough amongst witnesses and whistleblowers? And if so, can we maybe be given maybe stats in terms of how many are on it and what can I call not advertising, but outreach programs to make sure that this particular program is known, so that those that can benefit from it are then allowed that opportunity to come in. Chair, my last point is on the issue of training for prosecutors and all and sundry in the NPA. I view the response by a 14-year-old veteran prosecutor that they do not understand digital penetration, which is non-consensual, as rape. So the question begs, how do we continue enhancing and improving the skills of those that we trust to litigate on behalf of victims of crime in this country? So training for me is very important. So I'm interested to find out what training is there, what measures are there to improve the effectiveness and knowledge of those that are responsible for ensuring that the voice of the victims and South Africans as a whole are heard in such cases. Thank you very much, Chair. I will pause there. Thanks for the opportunity to participate in this discussion.
Thank you very much, Honorable Klopper.
Thank you, Chairperson. Firstly, I'd just like to express my deepest sympathy with the victims of the case. I think their courage to come forward must never be in vain, and today we honor them really by asking these difficult questions to the NPA. A lot of the details have already been covered by previous speakers, so I just apologize for any overlap that might actually occur. Chairperson, firstly, there was a piece that I didn't hear properly, so if I could just get clarity. Apparently there is the investigation taking place currently, and the two advocates, I think it was two advocates that are involved, are also from the soccer unit. Is this the same unit that Advocate Ntelwa is part of? Chairperson, my first question is, how did the senior leadership within the NPA allow prosecution of such national significance to proceed in face of the procedural irregularity? There was unamended indictments, unethical conduct, incomplete presentation of evidence. At no point in the 8 years did anybody in the leadership step in NDPP intervene. Were they informed of these irregularities as the case went on? And if so, why didn't they do anything, while the trial was on? I think it's very important in this case specifically that on the very same day of the acquittal, an NPA prosecutor, Ignatia Malakwane, appeared in the court on charges of corruption, extortion, and obstruction of justice. And the coincidence is not just disturbing, it signals like a possible leadership vacuum. Because the chairperson, this cannot just be accepted. Chairperson, I understand that there is a disciplinary in process, and I think it's going to actually hamper a lot of the questions. What I would like to know is the superiors that found out about all the WhatsApp and the police statements and the witness, witness statements that were told, that they need to stick to the police statements and so forth. Why wasn't this matter specifically addressed, when it happened? I understand the MP said that they didn't want to do inquiry while the case was ongoing, but that specifically, why wasn't it addressed? Because it would have massive impact. And, I also would like to know, what support exists for the NPA and for the victims in these high-profile cases specifically? And I mean, this is an 8-year ordeal. And these witnesses had to go through this for 8 years. Judge Kuman dismissed 31 charges because there was no evidence being led. I mean, this is extraordinary failure. And what message does it actually send to the survivors of sexual violence? The NDPP, said we shouldn't discredit, all the work being done. And, and while there might be very positive cases, that's no dispute. But, when you're the victim and then you become a victim of a failed prosecution, other successes don't matter to that victim. And I think that really needs to be, very, very strongly considered. The internal audit is going on, and what happened and who's guilty and who's not. And I'm very sure that this will be made public, made public. What worries me is in the last year that I've sat in this justice portfolio, we've heard many reassurances. So please bear with me. When the TRC matters came to the committee and the victims, they were felt let down by the NPA. We've heard of corruption trials that just don't take place, and it affects millions of South Africans. And now the cycle continues to very serious offences like the sexual offences. And Chairperson, it's not that I somewhat believe that this isn't only about this one trial anymore. It's about prosecuting authority that appears either incapable or unwilling to confront some internal rot that exists. And until these failures are addressed at the root, I think the NPA will continuously bleed. And I don't understand how they wish to restore this public faith in the justice system and in the NPA when they're continuing to let down South Africans. And I must say again, I reiterate, in no way am I saying that there isn't any positives, and I'm not saying that there isn't cases that were successfully prosecuted. What I'm saying is it doesn't matter to a victim that was let down by the NPA, and especially in such a serious matter, and especially when it comes to gender-based violence. Chairperson, I won't go further. I think many speakers have spoken and they've covered a lot, and there's many speakers still to come. So I'd just like to pause there. Thank you, Chair.
Thank you, Honorable Tsotetsi. Honorable Tsotetsi. Okay, let's pass. Honorable Dana.
Thank you, Chair, and good morning, and thank you for the presentation. Chair, poor cross-examination, amateur mistakes, unethical conduct in such a high-profile case, it's, to say the least, very, very disappointing. And even if it wasn't a high-profile case, it shouldn't happen in any case at all. So, yeah, many of my questions have been covered. I just have two more. The one is with regards to the delays in finalizing the case. It wasn't only the fault of the NPA, but in this to and fro and during this long time lapse, things did fall through the cracks. So we know our criminal justice system is broken at best. The NPA can only do what you can. But work can't continue to be done in silos, and we've seen this now since forever. We've spoken about this in so many meetings, and it's all to the detriment of the victims of the crimes. Work is being done in silos in the criminal justice system, in the cluster, and I'd like to know, are there any attempts or plans from the NPA's side to address these gaps between the different role players in the criminal justice system? So that's my first question that I've not heard any colleagues ask. And then the second one is, we know the NPA has many successes, it's not only losses, and we commend you for that, because the prosecutors especially work under very, very difficult circumstances. And on that point, I'd also like to express my condolences with the family and the colleagues of the prosecutor, Mrs. Sombulula, who was murdered recently. But the loss, Chair, of any case like this, especially with a scathing judgment like this one that was handed down, is one too many. So we welcome the consequence management that has been proposed or that has been initiated already by the NPA, but it's too late for the victims of these crimes. They are suffering secondary trauma. It's completely unacceptable, especially with the drive that we have against GBV in this country. We cannot allow something like this to happen. So what I would like to see is, or hear, and then eventually C is an absolute insurance that everything possible will be done to prevent something like this happening again, whether it be in the training of prosecutors, in the oversight of prosecutors, in the performance management of prosecutors. Everything absolutely has to be done, and we want the insurance for that. I think I can speak on behalf, and no, I'm not allowed to speak on behalf of the committee, but I'm sure that's what everyone wants to see. We cannot, this is such a disgrace, this is such a shame, and it's really disheartening to hear all of these things, amateur mistakes being made, and especially in a case where someone with such a high profile, someone in a position of power is acquitted, and the victims are being traumatized over and over and over again. And I think it was Honorable Swart who alluded to the fact that this is going to have a direct effect on reporting, especially where someone in power is the perpetrator in cases like this. So that's all for now. Thank you, Chair. If there's anything else, I'll raise my hand.
Thank you, Honorable Diana. Honorable Zodetsi. Okay, let's pass Honorable Mtaung.
Thanks, Chair, for the opportunity. Chairperson, I think most of my colleagues, they have already mentioned many points in this presentation. But Chair, I must just say that we are very disappointed of this case. Not only disappointed, we are even ashamed to talk about it in the public space. It's a very big embarrassment for our justice system, Chair. My only question, Chair, to the NDPP is that what is it that the NPA is doing to protect whistleblowers? Because I don't think we are doing justice as government to try and protect our whistleblowers that are assisting the government in different cases. Thanks, Chair.
Thank you, Honorable Zodetsi. Let's pass Honorable Mhlongo.
Thank you, Chair. I want to say that firstly, the NPA should really hang its head in shame for not only failing Cheryl Zondi and all the women who have been raped and violated by Omotoso, but they should be ashamed for their daily persistent failures in the different courtrooms across the country to the victims of rape, attempted rape, gender-based violence, domestic violence, and femicide. Now, the failure of the NPA to ensure that Omotoso is successfully prosecuted will make more women afraid to come out, for they know that they will be failed by the NPA and they will never find justice. So we must not shy away from raising that fact. That is now a fact that women will be very scared to come forward on such cases, especially when they have to go up against such powerful individuals like Omotoso, powerful individuals who are perceived to be men of the cloth, who are running big churches like this. Now, you will remember, Chair, that Cheryl Zondi was a little girl at the age of 14 when she was raped and her childhood stolen from her by Omotoso. She bravely testified in court for the whole world to see. Yet the NPA has failed her and the girls and women who were raped by Omotoso or who were sexually violated. Now, Advocate Batoyi must tell us what kind of a message does the NPA want to send to young girls and women in South Africa about not only their safety, but their cry and need to find justice when they are violated. Now, Judge Skuman in the judgment delivered a scathing judgment on the actions of Mr. Ntwela, Kobedan, and Goden, on their irregularities and their conduct. Now, if you check paragraph 40 of the judgment, it portrays a miscarriage of justice. The prosecutors were unethical and incompetent. Those are the words used by Judge Skuman. When the lawyers of the state are incompetent, it leaves the victims vulnerable. Where should victims go when we have incompetent and unethical lawyers of the state who are supposed to be, as Advocate Patoy explained, they are lawyers of the people. Now, in paragraph 47, Chair, we read it, we saw that the judgment labels the cross-examination of accused number 1, Timothy Omotoso, as desultory and in the extreme. It says that there was no thought that went into cross-examination. And it further says that cross-examination was shallow and lacking the intention to uncover the truth. That leaves little to be desired, and it says a lot about the NPA. Maybe, as I quote lastly for the from the judgment, Judge Kuman further finds that the cross-examination of accused 2 and 3 actually amounted to no cross-examination at all. Now, this begs the question, this cross-examination and this whole trial of Omotoso was broadcasted live. I do not understand how the NPA could not pick up the problems to actually begin with. I'm really lost how they could not pick up that there's problems in this case when it was broadcasted live for all to see. Now, NPA should really be embarrassed after having failed all of us as women and the girl child of this country. You know, after the judgment that was delivered, they should have gone, perhaps tried to save face by going to or putting up a proper appeal case. As they say, they want to appeal this matter. So we're hoping that they save face and perhaps put a solid case on this matter. And I want to know what guarantees are they that when they appeal and what measures are they putting in place to ensure that when they appeal, Omotoso does not apply for a mistrial. How best to ensure that we safeguard this case and we don't lose it in terms of NPA does not lose the case and on the basis of a mistrial. Perhaps Omotoso saying there's a double jeopardy on this matter. Now, soon after the judgment, NPA says they are trying to save face. They get SAPS and Home Affairs to open a case on the matter of Immigration Act. We get embarrassed again, Chairperson. You know, as the country and all of us who are interested in issues of gender-based violence and femicide in this country. And NPA itself gets embarrassed. We even fail on small technical issues. I don't know why the NDPP is mentioning that case of having arrested Omotoso, because they failed to deliver the man in court within 48 hours as stated in the Constitution of the Republic. He could not appear. So we're failing even on small issues. Technical issues, Chair. I'm worried about this case when we fail on a small technical issue. Now, did the NPA get an explanation as to why a WhatsApp group was created for the witnesses and why the content that was posted in that group has since been deleted? Is this a norm that witnesses in a case get to be put in a WhatsApp group? If not, why was it done in this case? In fact, Chair, the way things are going with this case, I'll not be wrong by assuming that the NPA finds joy in repeatedly triggering and doing secondary violation to women and children by their consistent failure to prosecute accused in cases of rape, gender-based violence, domestic violence, and femicide. Now, perhaps, you know, Chair, I was listening to the NDPP trying to pacify all of us here, telling us about cases they've won. She does not mention similar cases where the state has lost because of the incompetence of the prosecutors. But because we are being pacified, we are being managed, Chair, we are told about cases they have won. We're not interested in those cases. Thank you, cases you have won. There was justice for the witnesses. We are concerned about the cases you lose. We are concerned about this case of Omotoso. Another disturbing factor, Chair, in this case is now the death or the case where Ms. Pamela Mabini, the whistleblower on this case, was killed a few weeks before the judgment was delivered on Omotoso. More interesting, the person that the police identified as a person of interest in this case has also since been killed in a taxi rank in front of many people. So this indicates to us, we are wondering if this is linked to the case of Omotoso or it's linked to another case. So this is another case that we'll be watching with keen interest as the economic freedom fighters, because we're interested in knowing if the killing of Miss Pamela Mabini was linked to this case of Omotoso, and if this will not be another case that SEPS fails on it and labels it as a cold case, or SEPS will do their job, hand it over to the NPA, and will again have incompetent prosecutors who will ruin this case like they've done with this one of Omotoso. You know, Chair, I'm aggrieved, I'm annoyed, I'm angry at the fact that the NDPP says that in her report, like the rest of us, that they are shocked by the judgment. They can't be shocked about the judgment. We are where we are today because of the incompetence of her own prosecutors in her office. So it's not true that they are shocked. They are not shocked. Everyone could see when the case was ongoing that there's a problem. You know, on paragraph 5.2 of the presentation by the NDPP, it says that investigation into the conduct of Advocate Ntlelo and the other prosecutors involved in the Omotoso matter started in August 2024. Yet there's no report that has been finalized on their conduct to this day, Chair. So I want to know, since they are still busy with the investigations, the prosecutors that they are investigating who are involved in this matter, a very sensitive matter that that has tarnished the image of the NPA, are these prosecutors still at work? That's number one. If they are still at work, do they still get allocated cases of rape, attempted rape, gender-based violence, domestic violence, and femicide? If so, why? Are they suspended pending the finalization of the inquiry? If they are suspended, are they suspended with or without pay? And if they are not suspended, they are still reporting in the office. I'm interested in knowing, what do they do on a daily basis? Today is a Friday, is a normal working day. If those prosecutors are still in the office, what is it that they are doing to ensure that they also do not jeopardize this investigation into their conduct? Now, I want to know also from the NDPP, on cases of misconduct and irregularities of prosecutors, how long does it take to investigate and have a report on a matter? Do you perhaps give timelines on matters like this or not? If you do normally have deadlines or timelines, was the deadline to finalize this report submitted, given to the investigators, since the report and the investigation started in August 2024? If not, why not? If it was given, was it met or was it not met? If it was not met, why not? Does the NPA have mechanisms in place to track proceedings of cases allocated to prosecutors, or you only pick up problems with the way a prosecutor was handling a matter after a judgment has been delivered? Now, Chair, I want to raise another matter. You know, also Judge Skuman, I don't think should be spared from this, because in her judgment, she makes the victims to somehow look like they are to blame for the failures of the NPA. Now, Chairperson, another thing we're interested on is we need perhaps, you know, to get the Department of Justice and Constitutional Development to review the way cases like this, cases of rape, attempted rape, murder, gender-based violence, domestic violence, are handled. We need to amend certain sections of our constitution, because I tell you for free, it's a pity how the first 3 court appearances of an accused person on a sensitive case of rape, murder, attempted rape, domestic violence, you know, the first 3 or even more appearances, the justice is only interested in one person, is interested on the rights of the perpetrator or the rights of the accused. First 3 or 4 or more appearances of the accused when they appear in court, we are only talking about their right to get bail. Nobody is interested about the victim. Nobody cares how the victim feels. It's an indictment on our constitution, Chair. It tells us that something must be done. It ought to be changed. And the way questions are posed to victims of rape and gender-based violence or sexual assault in court leaves little to be desired, Chair. Witnesses has to recall what they were wearing, what their victim was wearing. Chair, sitting here, I don't remember what I was even wearing on Monday. It's not something I can remember. There's no, like, people have other things that they're busy with in life. And after being sexually violated and traumatized like that, I don't think it's easy for victims to actually recall and remember everything that had happened to them. Lastly, Chair, as we sit here today, we're speaking about this matter, and I heard that they were mentioning that they are prioritizing DNA. As we sit here, Chair, the SEPS Forensic Lab in Pretoria office, the roof is leaking, the building is in a dire condition. The whole upper floor of forensic investigators for weeks has not been reporting for duty. And this contributes to the continuous failure or delays of evidences in order to resolve cases of rape, murder, and similar cases. Yet we are made to believe that there's a will to resolve such sensitive cases, while evidence continues to be compromised and delayed. Now, the backlog that is going to come from that office, I know it's not the fault of the NTPP, is now an issue of SEPS, but the disaster of the backlog that is going to ensue from that office is going to delay a lot of cases that are with the NPA, Chair. And this is really a problem for us. So please, Chair, let's not allow the NTPP to pacify us and seek to manipulate us in telling us about cases they've won. Let's hear about the cases they have lost. How many cases they have lost, and what have they done to those people who, those prosecutors who lost cases because of their incompetence and their irregularities or their misconduct in handling the cases. So we must not be pacified by cases that they've won. They ought to ensure that they win cases. It's their job as lawyers of the people to win cases on behalf of the people. So we must not be drawn into perhaps be asked to clap hands for a swim for fishing. We are more concerned about the cases that they are losing and their failures.
For a fish for swimming, Honorable Mhlongo. You said for a swim for. You said for a swim for fishing, for a fish for swimming.
Yeah, a fish for swimming. No, it can't be that we're clapping for a fish for swimming, Chair. Winning cases is part of their job. They ought to do it. They ought to win the cases. So we are not going to clap hands for that. We are going to call them out when they are busy losing cases, especially high-profile cases like this, Chair. So I'll leave it there, Chair. Thank you.
Chairperson.
Thank you, Honorable Mhlala.
Thanks so much, Chairperson. Let me take the opportunity and greet everyone present in the meeting.
Honorable Mhlala, it's not you now. I thought there is a point you wanted to raise.
Okay, let me come to that, Chairperson. Allow me to speak. I'm taking the opportunity to greet all members present in the interest of time, and I will proceed by saying all protocol observed. Chair, I was calling order really to you. The fact being that when you came to us, you changed the sequence. You started thoroughly from number 1 until I was listening because I was writing when you took the names of the people that must come following each other. But when you come to us, it was Honorable Nazir Paulsen and it was myself and then Honorable Mhlongo. You then started with Honorable Mhlongo so that when we address this issue, we become disorganized as members of the EFF as if we are fighting amongst ourselves, of which you know very well that The first person to speak here was Honorable Paulson, of which I've spoken to Honorable Paulson. I will start first before Honorable Paulson come. So please allow me to present in that regard, Chairperson. But really, I see you being disingenuous. It was Honorable Paulson. I don't know why did you call Honorable Mhlongo.
Honorable.
Of calling Honorable Paulson, myself, Mhlongo.
Honorable Mhlala, we are in the Mosha leadership. We are in the Mosha because that's not even a point of order. And I would plead to you to allow me to chair and direct the speakers, and everyone is going to speak here.
But it's a point of order, it's order, because you have changed the whole sequence of how you were calling people.
Honorable Mhlala,
you just started by calling Honorable Mhlongo instead of
Mhlala, please,
the sequence. Because you want to disorganize us.
No,
but it's fine. I'm allowing you to chair the chairperson. Proceed.
And Mosha, Honorable Mhlala, we are the Mosha.
Who else Mosha, Yolan? And we are not going to allow that if uzodlala politics, because
I can even start. Actually, I can even start from the bottom. I can even start from the beginning. Please don't do that. Honorable Paulson.
Thank you very much, Chairperson. Chairperson, I would actually like the permanent member representing the EFF to go before me. I think it's a.
But Chair, can we have order? I don't understand why members of the committee want to chair with the chair. There is an order which is there's a directive which the chair is issuing that people must speak. Now we must be subjected to people determining who must speak before who has to speak before who. This is out of order, and I would like you, Chair, to really descend on this.
Yeah, that's order is sustained, Honorable Tsotis. You know, I've even skipped you when I called you and you did not respond. And there's really no issue about it. There's really no issue. And there's no issue even about a disorganization here. There's no one who's being disorganized here. We are discussing this critical matter. Can we please proceed as per how I have appointed out speakers? Please, members. Honorable Paulson, can you please proceed?
Chairperson?
No, wait, Honorable Mhlala, wait.
Can I come in?
Oh, no, wait, don't come in. Okay. Honorable Paulson, there are two issues, Honorable Paulson. Is either you are withdrawing or you proceed.
I would really not like to withdraw. I have.
Yes, please proceed. Yeah.
Well, thank you, Chairperson.
Honorable Mhlala, I'm still going to come to you. Proceed, Honorable Paulson.
Thank you, Chairperson, and once again, Chairperson, and to the members of the committee. And Chairperson, I was covered mostly, but there's one particular issue, or three actually, to Ms. Bonnie Karigamo, who heads up sexual offences and community affairs. So, and another member did cover this partially. On the 7th of March 2025, a community activist and a whistleblower in the Omotoso rape case and human trafficking, Pamela Mabini, was shot dead in the driveway of a home in Kabega. She was also shot by unknown gunmen in May 2018 after receiving threatening messages. Now, if this wasn't a clear indication that Mrs. Mabini or Ms. Mabini needed the protection, where was SOCA then? Wasn't their role to actually protect? Because part of their role is the creation of an integrated case management system that increases the conviction rates of perpetrators and gender-based violence, and to create a safe space for victims. So wasn't this is another failure on the side of the NPA to actually protect a key whistleblower in this particular matter. Then also Advocate Batoyi says she's going to appeal the outcome of the matter, but they've also going to deport Omotoso. We've seen with another perpetrator of GBVF, Shepherd Bushiri, where we are struggling to extradite a criminal to stand trial. So we're going to deport Omotoso and then appeal the matter. And when he's found guilty this time around, we're going to struggle to extradite him. And in the case of Shepherd Bushiri, there's also charges of rape against him. And then, Chairperson, the other one is even more alarming is, these are failing cases, but then they also fail to respond and prosecute cases. There's no prosecution around Marikana, the Zondo Commission cases, the Life Esidimeni cases. It seems as if cases that involves the black working class are not considered important. Last year, on the 14th of October, I laid a complaint against someone who participated in the genocide in apartheid Israel. Firstly, when going to hand deliver the complaint, I get assaulted by thugs that they employ as security at the NPA here in the Western Cape. There are other cases or reports on people participating in the genocide in Israel as part of the Israeli Defense Force. And what is very clear, it cannot be that there's insufficient evidence, because none of these people, in terms of the Foreign Military Assistance Act, have permission to go and participate in the genocide in Palestine. In fact, South Africa has got a duty to do everything in its power to prevent a genocide. But yet here in South Africa, these cases are not responded to. These reports are just put one side. There are South African Zionist organizations and the chief rabbi encouraging participation in this genocide, and nothing gets done about it because the NPA won't prosecute people who are guilty of contravening the Foreign Military Assistance Act. Why is the NPA turning a blind eye to these perpetrators of genocide? Why are they not prosecuting? Why can a chief rabbi go and encourage participation in the genocide? Why can our members of parliament go and whitewash that genocide over there? Because the NPA is weak, very weak. You can't even prosecute cases where there's blatant criminality. I'm not surprised that you fail at a successful prosecution of the Omotoso. The NPA is incompetent. It rots at the head, and something needs to be done, and it needs to be done very quickly, because we are degenerating as a state. So what is going to be done? Number one, about protecting whistleblowers like Pamela Mabini in the future. How are you going to address the fact that you want to deport Omotoso, but you still want to appeal the outcome of the matter? And how are you going to deal with these reports of South Africans participating in the Israeli Defense Force? Part of the genocide, the very genocide for which we took Israel to the International Court of Justice. I think it's really a contradiction that we take Israel to the International Court of Justice, we report people who participate in that very genocide, and you do nothing. We've got a duty as South Africa to do everything to prevent genocide. Yet you refuse to prosecute people who are participating in that genocide. Thank you very much, Chairperson.
Thank you very much, Honorable Paulson. Honorable Moshe.
Thank you, Mr. Chairperson.
Chairperson, after me is Honorable. After Honorable Paulson is myself.
No. Honorable
And
Mshala.
you say you're going to follow. You said you're not allowing. No, but you can't do that to us now.
No, you're out of order.
Because we can see your interest is not to see us presenting in this case.
No. There's no one.
Can't do that.
Honorable Mshala.
Because
Honorable Mshala.
Chairperson, stop being out of order and stop treating the EFF the manner in which you are treating us. You come with decisions that are not even, you're not supposed to be taking, because your intention is to remove
me. No, it means, Honorable Mshala, you were not listening.
Your intention is to remove
No, Honorable Mshala, please, man.
You said you are following the sequence. The sequence of Nazir Paulson is myself.
Mshala. There's no such a thing. I'm the one who was pointing out people
Please
here.
Tell me what is the sequence? What is the order?
What sequence? What order?
When you were
you're coming after Honorable Mashwe. Don't do what you're doing. It's unnecessary. You're diverting us on serious things here. Honorable Mashwe, please.
Honorable, no, Chairperson, you can't do that. You are very out of order.
Please proceed.
We are noticing what you are doing.
No. It's wrong what you're doing. You're diverting us.
You are wrong.
No, I'm telling you, I'm the one who
allow us to speak.
No, man. Honorable Mshala, please. Honorable Masha, please proceed.
But please assist us in terms of when am I speaking? Because it was Honorable Paulson.
Honorable Mshala, when I pointed people out, I named them by name. I said Honorable Swart, Honorable Breitenbach, Honorable Nomvalo, Honorable Matafa, Honorable Klopa, Honorable Totetsi, Honorable Dona, Honorable Mutaung, Honorable Mhlongo, Honorable Paulson, Honorable Moshe, Honorable Mshala, Advocate Sally. That's what I said. It means you are not listening.
But the sequence was not like that.
Louder. No, I said it louder. It means you're not listening. But
it's fine. We'll allow you the manner in which you want it. It's okay. Thank you.
Don't do this, please.
No, it's you who's out of order, Chairperson. You can't do us. Just change along the way. What is the problem with you? Why you don't want to allow us to speak?
Please proceed. Don't do this thing you're doing, please.
Honorable Chairperson.
You're very out of order, and we're not going to allow that.
Honorable Chairperson, thank you for the opportunity to contribute and to raise questions to the NPA. I can confirm that when you mentioned my name, it was after Honorable Paulson. That I can confirm. And thank you for sticking to that. Advocate Batohi, among others, said Omotoso is facing deportation. Now, this came as a surprise to me, because we were told in one of the news that Omotoso is going to face retrial. He will not be deported. Now, we are not sure what is what. So I should ask the NPA and the NDPP whether they have made a request to the Department of Home Affairs or to the Minister of Home Affairs not to deport Omotoso until the conclusion of a retrial, or have you approached the court of law to ensure that he is not deported before a retrial has taken place? We know that it is difficult to deport a person and bring him back when there are cases against them. My predecessor was correct in what he said about other cases of people that were deported. So if a formal request has not been made, I want to appeal to the NPA to make a request to meet with the Department of Home Affairs or with the minister to ensure that he is not deported until a retrial has taken place and hopingly until he is found guilty, as a majority of South Africans believe who have been following the cases. And my second question, Advocate Batohi again said that she is willing to meet the victims of these heinous crimes that have taken against them. She is willing to meet them. My question to her is whether it is just a willingness or is it a decision? I think she must come to a place where she decides, I'm going to meet them. And it would be good for her to tell us, meet them to say what to them? To say what? To sympathize, to reassure them that justice will be done, but I think it would be a good thing for her to meet with them. In the press statement I made on the 3rd of April, after the acquittal of Omotoso and his co-accused, among others, I said the NPA needs to apologize to the public because we are all devastated, we are all let down as a country, and they needed to say something like an apology. If I missed it, I want to be reassured that an apology has come out and be told when it did come from the NPA. And if it did not, it would be a good thing for Advocate Batohi to make that apology when she finally gets an opportunity to meet with the victims. And I hope that it will not be too late, that she will meet soon with them. And my third question, Judge Skuman criticized the prosecution team for poor cross-examination. Now, as this was a high-profile case, I am surprised, and many people are surprised, that juniors, inexperienced people were used in the prosecution. I want to know why the NPA did not assign to this case, or Omotoso case, senior and experienced prosecutors to ensure that he and his co-accused are found guilty for what they have done. It is embarrassing that after about 32 cases, well, lastly it was 32 cases, started with a double that number, that they were reduced until they were 32, 31, and all of them, they were found guilty because of poor cross-examination. Where were the seniors? And as the trial continued and people could hear and see that the prosecutors were definitely fumbling, why was there nothing done? Because members of the NPA were watching, hopingly the procedures, they were watching, and when their team members were not doing well, I think a supervisor should have stepped in. There were enough indications and red lights that they were not going to win the case. But nothing was done, as if that was the outcome they wanted, that Omotoso should be acquitted. So as there will be a retrial, hopefully there will be a retrial, we want to ensure that the NPA, and I want to appeal to Advocate Batohi, get the best of your best, regardless of whether they come from Messina, Limpopo, Gauteng, or where, but get the best of the best among your team to deal with this case, to ensure that that man pays for the crimes he has committed against innocent women who were in church. And my last question, has the NPA or NDPP made an appeal, made an application to bar Omotoso from carrying on with church meetings where he will get opportunities to get close to ladies in his church that he sexually abused and raped them? There has to be an appeal. Other women have to be protected. As far as I am concerned, that man is dangerous. He should not be allowed to be around women. He should not, particularly in a church environment. So if an application is not made, then the people are going to be harmed again. Innocent people are going to be harmed. And I must salute the mayor of East London, the mayor of East London municipality, who refused him permission. He applied to have meetings, church meetings around East London. He refused. He did the right thing. And I wish that the NPA would take his example to make sure that this dangerous man does not come close to women in church again. If he wants women, must go somewhere else. But in church, women and everybody else must be safe. Thank you, Mr. Chairman.
Thank you, Mfundisi. Honorable Mhlala.
No, thanks so much, Chairperson. Let me shoot straight to the issues of the day. My name is Honorable Rebecca Moshala, a member of parliament deployed by the Economic Freedom Fighters. The only organization that consistently stands with the dejected and forgotten masses of our people, especially when the state, which is constitutionally bound to protect them, instead chooses to harm them. Chairperson, we want to put on record that the justice system in this country has collapsed. The South African Police Services, the NPA, and the judiciary. There are a lot of issues happening in this country, and we no longer have confidence in the prosecution or the entire justice system. This system has collapsed, Chairperson. I therefore not going to be single side in approaching these issues. I'm going to look at the overall context of what happened, because isolating any one part would not serve justice. Yes, the NPA has failed, dismally so in this case, but the court also had a duty to assist the process. We will not treat this matter, I think, in isolation, because doing so will ignore the collapse we are seeing across the entire, criminal justice system. Chairperson, as the Economic Freedom Fighters, based on our thorough observation on this case, the EFF is extremely concerned about the manner in which this trial was handled by both the judiciary and the National Prosecuting Authority. We believe both institutions failed the victims of gender-based violence, more especially this one in Omotoso case. Chairperson, under Advocate Shamila Badoy leadership, the NPA has repeatedly failed to demonstrate competence and integrity in handling high-profile prosecution, the Singiso Magaka matter, the Senziwa Meiwa matter, and many more. In this case, the NPA was very disorganized, unethical, and unfit for the scale of the matter, as clearly recorded in the attached NPA report and also in the judgment itself. So I want to start by showing the key failures. The lead prosecutor, Advocate Ntelo, was found to have withheld critical contradictions in witness statement and even suggested coaching witnesses to commit perjury. The judge found his conduct grossly incompetent and dishonest, yet the National Director of Public Prosecution failed to take decisive preemptive action to protect the credibility of the trial. So the entire prosecutorial team, under the supervision of the National Director of Public Prosecution, Advocate Badoy, collapsed under pressure in one of the most sensitive GBV cases in this country. Chairperson, we are forced to discuss prosecutorial incompetence in a case that carried the cries of over 11 survivors of sexual violence. That alone should compel this committee to demand Advocate Badoy's resignation. He has failed the justice system. Another point, Chairperson, I want to bring, Judge Imas Kuman has served in the High Court since the year 2000. Her experience spans more than 25 years and is not our view that she lacks understanding of her judicial duties. However, her judgment in this case raises deeply troubling concerns that must be addressed. I'm going to touch now the observation that we have observed in this case. The judge did not adequately engage with the accused version. We note that the court failed to critically engage with the version of accused number 1, Omotoso. This is concerning, particularly given the detailed examination of the 11 complainants' testimonies. When you look at the presentation of NPA, paragraph 3.6, they say that the accused denied all the allegations under cross-examination. They further state that the cross-examination was extremely poor. There was no proper testing of complainant's version, nor of the accused version. That is paragraph 59 of the judgment. Despite his blanket denial, the accused was not pressed on specific factual contradictions. These omissions is a stark considering the complainants consistently described being summoned to Omotoso's room, massaging his feet, being assaulted, and then forced to clean themselves. This pattern should have prompted deeper scrutiny. It did not by the judge. Observation number 2 that we have observed, the court ignored common cause facts. Certain facts, such as the practice of foot massages in a private bedroom, were not disputed, yet not meaningfully interrogated. It is common cause that the complainants massage his feet according to the complaints. It is generally during those appointments where it is alleged that he sexually assaulted them or raped them. It is in judgment, paragraph 8. So, Chairperson, why would a religious leader repeatedly call young girls into his private quarters for this task? The court failed to confront this question, creating a judicial blind spot. Observation number 3, Chairperson, the court did not explain why 11 complainants would fabricate similar allegations. The judge failed to provide any rationale for why so many women, unrelated and from different contexts, would concoct coordinated lies. While not in a single paragraph, the judgment offers no analysis of this obvious question. Your body parts will be scattered all over, and dogs will drink your blood in the street. That is in the judgment, paragraph 20. So, Chairperson, in our analysis and our observations, this threat shows spiritual and psychological domination, not fabrication. The absence of motive for 11 people to lie should have raised judicial concern. So we go to observation 4, Chairperson. The judge ignored relevant legal precedents. The judgment does not reference the Supreme Court of Appeals ruling in the State versus Mafalajiso 2005. Despite clear contradiction between complainant's earlier statement and court testimony. A legal precedent was never cited or applied in this judgment, yet it provides the proper method for handling inconsistencies, a central issue in this case. Chair, in terms of observation 5, the court used the prosecution incompetence as an excuse to disregard evidence. The judgment most critical turning point lies in paragraph 59. The primary factor was the lack of cross-examination by the state prosecutor. It shows that the court leaned too heavily on prosecutorial failure rather than using its own powers under Section 186 of the Criminal Procedure Act, which empowers judges to call additional evidence where justice requires it. The function of the court, chairperson, is not that of being a neutral umpire. You must try to assist the court. So in that regard, I've got a question to the NPA. Did the NPA raise concern with the judge about invoking Section 186 to call necessary witnesses? Did the NPA consider applying for the court to step in where the trial was obviously going, when the trial was obviously going, of course? Did the NPA, under the leadership of Shamila Batoyi, advocate, try to intervene in that regard? We must not be told when things have collapsed and they see now that they are in trouble, they come here and say that we are intervening, when everything has actually collapsed. Another observation is the issue, that one I think I've already touched on it, of Advocate Ndela, who was grossly incompetent and very dishonest in that regard. That shows the failure of NPA in such a very high-profile case in South Africa, where the justice system was supposed to prove itself that it is capable in handling matters such as these ones. Another observation, the National Prosecuting Authority failed to prevent or correct these failures, despite being aware of red flags. The NPA reinstated Advocate Ndela after removing him following just one witness. Why did the leadership in the Eastern Cape reinstate Ndela despite internal warnings and known misconduct? Was the NPA aware that such a move would compromise the integrity of the prosecution? This investigation started in August 2024 as per the presentation. And there's a view that the expanded team will finalize the investigation by mid-June 2025. So, Chair, the NPA began investigating only after the case have collapsed, actually, confirming institutional delay and negligence. Chair, another observation in this matter that we want to also raise is the issue of the NPA may be undercapacitated in handling rape cases. With over 40,000 rape cases reported annually in South Africa, many require specialized prosecution, something clearly lacking, I think, in this case. So what plans exist to capacitate, train and deploy prosecutors equipped to handle GBV-related matters with the sensitivity and professionalism they may demand? So, Chairperson, we want to give you an ultimatum of what must happen. We are requesting the Portfolio Committee take a decision and request Advocate Shamila Batoyi to step down. And if she refuses to step down, Parliament must initiate her urgent removal, because not so, the collapse of justice system for GBV cases will be endorsing them, also be endorsing the corruption of prosecutorial ethics and erosion of public faith in the judiciary. The other matter that I want to raise before the Portfolio Committee is the matter of Tswetswe. I formally would like to raise concern regarding the handling of the case of Tswetswe at Matatiele SAPS, which has reportedly been referred to the Senior public prosecutor, according to the information that we got from her mother. But according to the mother, she's very distressed about the lack of communication, transparency, and accountability from the side of the police. And also, I won't say the prosecutorial team, because the information she got is that the case is being referred to the prosecution to take a decision if they are prosecuting, they are continuing with the prosecution. So we are requesting that this case be given the attention it deserves. We don't want to see this case going into the same routes as what we see with Omotoso case. So let's make sure that we attend to the case as soon as possible. According to the mother as well, she received clothes that she was told they are going for DNA testing, but she did not get information of what is happening with those clothes. What is the results, the outcome of forensic testing, particularly on the clothes that returned to the family. So we are also requesting that a direct liaison officer or victim support officer to be assigned to the family to ensure consistent and human communication. Lastly, Chairperson, is the matter of Pretorius. Chairperson and honorable members, what the NPA is doing is not justice, it's a manipulation. The appointment of Advocate Pretorius, who led evidence during the Zondo Commission, to now advise on prosecutions based on that same evidence is unethical and intellectually insulting. This is a clear case of the NPA playing both referee and player, undermining public trust, internal capacity, and basic fairness. Even worse, Chairperson, the NPA lobbied for him on national television before any formal process was announced. That is not accountability, Chairperson. It is arrogance, actually, on the side of the NPA. So, on what legal and procedural basis was Advocate Pretorius appointed? And was the position publicly advertised? How does the NPA justify appointing someone to advise on prosecution based on evidence he helped lead without acknowledging the clear conflict of interest? Chairperson, we are not going to allow that. As the EFF, we are against that thing. It must not ever happen. We are not going to allow people run the NPA as if it's their own personal firm of law. We are not going to allow that. So Advocate Pretorius cannot lead evidence and at the same time come now and advise in terms of how to prosecute those people that they've been mentioned to be implicated in the state capture cases. So we need to look into that, and we are not agreeing with it. Lastly, Chairperson, who authorized the NPA's public lobbying for this appointment on national TV, and were public funds used to promote this decision? Thanks, Chairperson. I'm done. Thank you.
Advocate Sally.
Thank you, Honorable Chair. Thank you, Chair. Good morning. Assalamu alaikum, honorable members, NDPP, and all on platform. As Al-Jamaa, we are disappointed is a mild word. We are disgusted, embarrassed at what has transpired in this Omotoso case. We duly note the duties of the NPA and structures in place and the work being done under very difficult circumstances. We are aware, none more than those who has worked in the institute of the NPA, of the duties, responsibilities, and work done. The details provided by the NPA, it is clear it is to appease and soften the blow of repercussions due to the failures in the NPA that is currently being exposed. 77% conviction rate in prosecution does not speak to the matters withdrawn in the NPA and the reality of no reporting due to many having lost faith in the justice system and in the NPA. And I know there are entities who despises the fact when we actually raise the fact that justice is failing us and the wheels of justice are currently falling off. And part of the responsibility is because of the NPA. 8 years, Honorable Chair, to complete a matter. We require a complete breakdown on where those failures occurred. And what we will find is that many cases, and there are many delays in the justice system and in the NPA that are failing our people of this country. The Omotoso case exposes the failures in the NPA, but it also exposes the lack of oversight and accountability. The lack of training and ethics and discipline is highlighted of those in prosecution, and we wonder what disciplinary steps will be taken. A serious matter where alarm bells has been raised surrounding the prosecutions in the matter has been blatantly ignored. The NPA today, we query the failure of the CA to put in checks, balances, and accountability. Oversight was seriously lacking in this matter and needs to be responded to. What oversight was placed whilst the investigation of this body? Where was the oversight of the seniors, fully knowing that this matter was gathering a lot of media attention and it's actually a very serious matter? Then I would like to know what is the years of relevant experience of the teams of prosecution that was considered and assigned to this particular matter. And the key word here, Honourable Chair, is the word relevant experience. The lack of leading evidence as is highlighted in the judgment, and it is absolutely shocking. It's actually appalling. Had this matter not had media attention, it makes one wonder how many cases are falling through the cracks of the NPA due to the concerns of lack of ethics and the ability of the prosecutors. Why must a matter have media attention before it comes to this particular portfolio? How many victims are we failing? We cannot ignore the trauma of the victims by people that is alleged to be the people's lawyers who have failed them. What systems is being put in place to assist the victims, and how is this victims going to be compensated? We talked about secondary degree trauma. I think that the trauma that has been suffered by these victims are far more. The NPA should be held accountable for their failures. We note that there is senior counsel and senior individuals assigned to these matters, which is another failure on the side of the NPA. These senior individuals had to be appointed at a long time ago at the beginning of this matter to investigate, prosecute without fear and favor or prejudice. It is heartbreaking today that an institution that's supposed to be one of the prides of our nation, because the authority that they hold and the power that they hold is failing the victims of our country and prejudicing the victims of our country. We welcome the investigation being conducted, but demand that this investigation be expedited. We are shocked about the lack of sensitivity on WhatsApp groups, where complainants are placed onto one WhatsApp group. And Honourable Chair, it was mentioned before, but we need to know what was the content and what was the purpose and discussion on these groups, because it will be highly concerning that complainants are discussing the matters in one WhatsApp group, and these same individuals would end up having to testify on these matters, and it can impact on what is being said in court. We note all the efforts being made now by the NPA to rectify their wrongs, and we need to note that while an appeal is primarily concerned with legal questions, it's not entirely based on law, not facts. Appeals can challenge the application of the law, the facts of a case, or the factual findings themselves, if it can be shown that the trial court made errors or misapplied the law. I don't want to go into too much of the merits, because we know that that will now be under investigation, and it will also be brought before the appeal court. Just makes me wonder, where was all this efforts? And ultimately, once again, these other victims, which is the taxpayers, who is going to ultimately also be impacted. by monies having to be paid because of prosecution failure. The accused Omotoso will now be deported and the victims will be denied justice, Honorable Chair, and that is the reality. And the NPA will ultimately have to bear the consciousness of the fact that this person is a threat to society globally. Further, Honourable Chair, I want to place on record and concur with Honourable Paulser, is the failure of the NPA to investigate and prosecute serious crimes and crimes committed against humanity. Not one South African has the right to be fighting in the IDF. But to date, despite cases laid at the NPA has failed to investigate and prosecute the charges against foreign mercenaries. Do we lack the skills in prosecution to investigate and prosecute these type of matters? That is another question. And maybe that is why Advocate Shamila Batoy is probably dodging the bullet on that particular matter. The lack of communication and evading of these matters also speaks to how prosecution is evading matters within our own country. Do we lack the resources? Do we lack the relevant skills and qualifications in the NPA? And also, another factor of concern is the arrogance that has been displayed for a very long time in the National Prosecuting Authority and in the NDPP's office. So, Honourable Chair, one of the things that is very important here is that the investigation be expedited and that we are all answerable to South Africa with regard to not just this matter. This matter is being highlighted, but Honourable Chair, I can promise you there are many of a similar matter that is before courts and not before courts, where the NPA and the NDPP's office is failing South Africa. And I will too duly note that Shamila Batoy needs to be removed from her position. And I thank you, Honourable Chair.
Honourable Zotezi.
Yeah.
Honourable Zotezi.
Yeah, I think if my hand's still up, might have been the legacy hand. I've been covered by honourable members on other issues that I would have wanted to deposit. Thank you.
Thank you very much, Honourable Zotezi. NTPP. I've got some.
Chair, sorry, you might have not seen my hand. I came in very last in the queue. Very briefly, please.
Oh, no, you were not there, Honourable Nyamanye. You joined late.
Yes, I agree.
You were not there. Don't say I didn't see your hand. You were not there.
Oh, okay.
Can we do this, Honourable Manye?
Sure.
I'm going to pose questions. We allow them to reply. If your issues are not covered, we allow you to ask them. Please.
Mine was going to take just 1 minute, Chair, please.
Okay, let's give you a chance. Fine.
Thank you. So that when the Chair has spoken, we don't speak after the Chair. Chair, mine is a brief one. Under a quick theme of the fish rots from the head. And just a quick summary, Chair. I mean, we're sitting here, as political parties in Parliament, we differ on many things. But on this one, we seem to be all united. Here's an executive summary, very briefly. The NPA has failed in the extradition process of the Guptas. They were using defective warrants and all of that, and the court has ruled on this. This is not me saying this. The NPA has failed in even doing a proper risk assessment on Bushiri to check if he's a flight risk or not. We're sitting now with a fugitive in Malawi. The NPA has failed to conclude on the Makaka case, has failed to conclude on the Meyiwa case. I mean, what a very glaring thing here, where even some of the people that were at the scene of crime, as we speak today, 10 years later, some of them have still not even appeared before the court. They have bungled up a whole lot of cases there. Kokomachela case, we're still waiting on the AKA case. We're still waiting to hear what Advocate Batoy is going to say about the fake it till you make it, a charade that people are doing there. Now she has bundled the Omotoso case. And on Wednesday this week, the MK party on the member statement raised the issue of Advocate Pretorius. This